Conflict of interest. It's a phrase we've all heard and probably thought about when a problem has come up. However, as a club leader, it's important that we have the foresight to deal with these conflicts upfront when possible and have a process in place to handle issues when it's not. In today's session, we'll talk about what constitutes a conflict of interest and what goes into a conflict of interest policy. We'll also talk about the legal and ethical impacts infractions can have on your club. We'll wrap up by sharing a few additional resources that can help your club get started. There are many ways you can define a conflict of interest, but today we will use the one provided by the IRS. A conflict of interest occurs where individuals' obligation to further the organization's charitable purposes is at odds with their own financial interests. However, it's important to keep in mind that a conflict of interest can go beyond just financial interests. A conflict of interest can also impact things like power structures, spheres of influence, and much more. Avoiding a conflict of interest is an important part of an organization's fiduciary responsibilities. As you likely know, a nonprofit's board of directors is charged with upholding these same responsibilities. Avoiding a conflict of interest is paramount to the duty of loyalty. This means putting the interest of the club above that of the individual. As Board Effect, a governance technology solutions provider who works with nonprofits and educational institutions, explains, a conflict of interest can also be known as a duality of interest. In these instances, an individual has a barrier that prevents them from being impartial and/or loyal to the nonprofit organization they're serving. A duality of interest can arise from professional, personal, or voluntary positions and relationships. Another type of conflict of interest are those termed as apparent. Apparent conflicts of interest occur when an outside third party questions whether a board member can be objective due to known competing interests. So now that we know what constitutes a conflict of interest, let's consider how nonprofits must formally handle them. This begins with a written document known as the Conflict of Interest Policy. The Conflict of Interest Policy should ideally be reviewed on an annual basis by the Board of Directors and other key decision-making volunteers and employees. It should be signed, dated, and retained with official club files as part of the organization's record-keeping procedures. We also recommend that a club have a legal professional with an expertise in the subject matter review the policy document to ensure that everything's in order. Board Effect recommends that a conflict of interest policy contain 4 sections. First, the purpose. What is the intention of the policy? Next up, definitions. Clarify common terms that are used within the document so that there's little room for misunderstanding or misinterpretation. Procedures should cover how the organization is going to handle conflicts of interest, covering everything from the disclosure process to how the club will manage discussions and voting. And finally, the policy should include details on what constitutes a violation and the ramification that will occur as a result. As noted on the screen, we recommend reading Forms 990 and 1023 from the IRS for further information on federal requirements. Many states also have their own separate specific statutes, so your club should make sure to inquire with its charitable registration agency and/or an attorney to ensure all requirements are met. Let's look at a few examples of a conflict. For our purposes, I have organized them into 3 areas. First up, there are those that can occur when working with or for a nonprofit. This could be when a decision maker works for a company that wants to do or currently does business with your club, whether it's with or without a contracting process. It could also be direct hiring as an employee of the organization, such as a club administrator or a paid camp director. There are also instances commonly known as nepotism, where a family member may work for a company trying to get business with your club, or even trying to get hired as an employee of the club. Finally, an article by Steve Milano for Cron also points out that it can be even extended to individuals who own stock or stake in a business that works with or wishes to work with a nonprofit. Next up, we have the area of advocacy. This is probably more unlikely to come up in a Sertoma club, but should still be considered. Advocating for or against specific public policies, especially when it's for financial gain, can come in direct conflict of interest with board service. And finally, we have conflicts of interest that arise due to membership and or leadership in other membership and voluntary organizations. Examples include conflicting competing fundraising efforts and priorities, access to your club's proprietary information that could be misused for the gain of another organization, and conflicting roles of power or leadership in two or more organizations. As we've said, disclosure plays an important part in a conflict of interest policy. It relies on board members and other identified parties to accurately and honestly disclose all professional, advocacy, and affiliate or membership relationships that can impact the way a club does business. This should be done in writing on the club's disclosure form and be retained for the course of board member service. It should also be made public to board members or other decision makers when decisions arise, if not before as determined by the board of directors. To help simplify the disclosure process, many boards will hold an annual discussion to discuss the types of situations that can constitute a conflict of interest, according to the National Council of Nonprofits. The policy document is then updated to reflect any new additions or changes. One of the main goals of a conflict of interest policy is to ensure that all members of the board are working from the same place. The needs of the organization, and thus the board, must come before the individual. A policy also helps create more harmony in how board members work together. Board Effect calls this creating a culture of candor. They explain such a culture can help people to express conflicts of interest candidly and confidently without fear of judgment. The hope is that these compliant, more unified boards will eventually get to the point where they can recognize personal conflicts when they see them. This leads us to the issues that can arise when a conflict of interest occurs. On one side, we have the more ethical implications. Chief among those is the idea of mistrust. If members of your club do not believe its board and or its individual officers and directors are serving in the best interest of the organization's mission, they're not going to stay as a member or supporter of the club. When these leaders are elected or appointed, we are trusting that they are going to do their very best to represent, helm, and support the club now and in the future. Inequity can also be prevalent when conflicts of interest arise. We have an obligation to our membership to be fair. We can't give others advantages to the detriment of others when the goal is any sort of personal gain. Leaders shouldn't be able to or allowed to use their power to impact the outcome, consciously or unconsciously, if it's not in fairness and respect to the club. And finally, transparency. Sertoma clubs are 501c3 organizations, which means that transparency is incredibly important to our longevity. Our members, donors, and other stakeholders need to trust that we're handling funds and decisions appropriately. When we're not upfront about certain aspects of our business, we risk severely damaging our reputation as a charitable nonprofit. Then, on the other side, we have the legal ramifications of personal conflicts. On a federal level, the IRS has an oversight role with all charitable organizations. Therefore, the IRS notes that they have made a concerted effort to provide organizations with strategies to help them avoid the appearance or actuality of private benefit to those in positions of authority. You can read more about this by searching for Form 1023 on irs.gov. Violations of conflicts of interest standards on a federal level can lead to the revocation of an organization's tax status. They can also lead to penalties, also known here as intermediate sanctions, that can be assessed toward an individual, an organization, or both. Many states have their own statutes and policies that guide how conflicts of interest should be handled. It can oftentimes impact the organization's status with the agency with which nonprofits must register on a state level. States may also enforce their own financial penalties, so I'd recommend once again that you connect with the aforementioned agency to learn more about what this process entails in your state. Finally, let's not forget about civil litigation. Your organization could be potentially held accountable if such a case were to ever come forward. We don't want our clubs to ever be sued, obviously, so being vigilant and aware of this subject matter is an easy thing we can all do to help prevent that from ever happening. A note on board meeting minutes. Conflicts of interest that arise in meetings should be annotated in the minutes according to both the National Council of Nonprofits and Board Effect. It should name the nature of the conflict, the director impacted, and how it was managed. Experts suggest that the minutes clarify whether the affected director was present for any discussion. The minutes should also include if any kind of vote took place and if the director with the conflict was allowed to vote or if they had to abstain. You might also want to consult with your club's legal professional to see if they would want anything else included for the sake of due diligence. I wanted to provide a few additional resources to help your club be successful. Displayed on the screen are 3 tools that provide further explanation on the subject matter and templates from which you can begin. Please pause the recording now to take down these links and check them out after the video has concluded. Sertoma has been around for over 100 years, and we want to be around for at least 100 more. To do so, we must continue to have an ethical, law-abiding culture of clubs that value trust, fairness, and transparency in our mission, membership, and fundraising work. An important part of this means that we continue to assess and address conflicts of interest. While this session may not include everything you need to know on the matter, it's a good starting place that we hope you have found beneficial. You can find additional resources and training videos on the resources page in the Member Center at sertoma.org. You can also connect with us on our members-only Facebook group on the link on the screen.